The petition for complete estate settlement. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine the petition for complete estate settlement. This is a form, a SCAO form, State Court Administrative Order Form, PC 593. PC stands for Probate Court, and this form is used when you're closing the probate estate formally. Now, whenever you're administering a probate estate and you get to the end, you really have two options generally. One is to close it informally, and the other is formally. There are times when the probate court mandates that you close it formally. So this process, this petition for complete estate settlement, is the formal process to close the probate estate. Now this form, this SCAO form, is readily obtainable through the internet by looking for the PDF, or you can contact my office and we'd be happy to provide you with a copy. With all SCAO forms, they are driven and give rise or are created by virtue of various statutes and court rules. At the bottom of my screen, you'll see a floating arrow, and it's pointing to the various statutes and court rules that direct this particular pleading. Now, of course, a close examination of these statutes and court rules are really critical to understanding how to complete it, and we urge you to do so with the assistance of an attorney, or you're welcome to contact my office. Let's examine each of these statutes. The first one is MCL 700.3402. This particular statute provides that the probate court can determine formally the testacy of the individual that has died. And what that means is that through a petition, you can determine whether a will is valid or whether the person died without a will. We call that intestate. And this process can be done at the beginning of the probate administration, and it also can be done at the closing through the petition for complete estate settlement. MCL 700.3952 is the statute that specifically dictates and drives that a personal representative can file this petition to close the estate. But interestingly, an interested party, meaning an heir or devotee, can also file to close the probate estate if the estate has gone on for over a year and the personal representative has not yet closed the estate. So for example, you don't see this very often, but if the personal representative is dragging their feet, the interested party can bring forth a petition to close the estate. The reason you don't see this very often is when they are dragging their feet, usually there are other pleadings that are filed rather than a petition to close the estate. Now, in this statute also provides that you can file with it an accounting as well as a schedule for the distribution, but it's not a requirement for purposes of the petition. There's also a court rule that is part of this petition for complete estate settlement. It's 5.311, and it directs the manner in which you can close a probate estate. And I mentioned it earlier. You can close an estate informally with a closing statement or a sworn statement to close, summary proceedings, or you can close it formally through this petition for complete estate settlement. So let's work our way through the document. Top left corner, you'll see that the county is identified, and the top right corner in the blue rectangle, the case number. Pretty easy to find off of the probate pleadings. The next section is the estate name, of course, the person that died, their name. We want it to be consistent all the way through, so we typically look at the letters of administration, letters of authority, and use the same name and identification that's used there. Section 1 identifies who's filing. That you are the personal representative and you were appointed on a particular date. And it identifies whether you were appointed formally through a court, which would have been a petition, or informally by the court register. Section 2 provides whether there has already been a determination of testacy. And again, the word testacy relates to whether a will has been admitted formally to the court and have been approved by the court and accepted and admitted. And you can identify whether it has already occurred or it has not already occurred. Section 3 is an update really as it relates to the interested parties' addresses and names. So for example, at the onset when the original petition was filed, there may be different names and addresses identified and people may have moved during the pendency of the administration. So this provides the court with an update of the names as well as the addresses of the interested parties. Section 4 is really an important section. They won't let you close the estate, of course, until the time for presenting claims have expired. And we're talking about creditor claims. So again, for known creditors, you are going to give notice directly to the known creditors through the notice to known creditor statute. And then for unknown creditors, you're going to notice through publication. Now, there are also times where you may not need to give notice this way because the statute of limitations has expired. More than 3 years have passed since the decedent died. So again, you're making an assertion that the time for presenting claims for creditors has now expired. Section 5 relates to whether all the claims have already been resolved. Claims that have been presented have been resolved, or whether you're asking the court to resolve them as part of this petition. Section 5, second little checkbox, relates to this process of using a schedule. And the schedule is a separate SCAO form, of which I've done a YouTube video that discusses that if the court approves the petition, you're then going to make payments to either the creditors or distributions to the heirs, and that you're asking the court to approve that schedule. So it can be a part of this petition for complete estate settlement. Section 6A, again, identifies whether the person died testate or intestate, with or without a will. And Section B identifies the information relating to the will and or codicil. And then C provides whether there has neither a will or an authenticated copy was presented, but there may be a copy of the will that you're asking the court to approve, a lost or destroyed will. And then if it was informally presented, you'd identify that date in Section D. As we move further down on that document, you'll see that there's additional information in regard to the request of this court or information about the heirs of the estate. On the back side of the form, here's where you're making the request of the court. You're requesting of the court to first, under Section 12, if you're needing an order determining heirs, you want to identify the names of those heirs that you're asking the court to determine. And again, if this was done at the onset of the administration through a petition for probate, you're not needing to do another order determining heirs. But if it wasn't determined, or if the will was not admitted earlier in the process, you would identify it here. Under Section 12, second checkbox, if you've attached a final account to the petition, you would check that box, and if there were any attorney fees or fiduciary fees, you'd also include that box to be checked. Again, the next section relates to the distributions that may be referenced in a schedule, the other SCAO form that may be attached to this petition. You'd check that box if you are attaching it. And then, of course, if this is the final act of the personal representative and you're asking the court to close the estate, you would check that box asking not only do you want the estate closed, but you want the personal representative's responsibilities and duties to be discharged. And it's a critical function here because you're asking the court to approve all of the actions of the personal representative, and now you're asking for them to be discharged in their role. Now, this petition would then get filed with the court, and there'd be a hearing before a probate judge. Now, if all of the interested parties waive and consent to the petition itself, the court can act on the petition without the necessity of a hearing. But ultimately, the goal is to get an order for complete estate settlement. And that order I've also done in a separate video explaining how that order gets entered by the probate court, signed by the probate judge, and the effect of that order as it relates to the personal representative's liability and their discharge of their responsibilities. Now, on this form, with all petitions, there's a space for the petitioner to sign and put the relevant information, their case contact information, as well as if there's an attorney, there's a space for the attorney to sign the petition also. There's also a penalty of perjury clause that exists on all of the SCAO forms, indicating that the signer of that document certifies under the penalties of perjury that the information is correct to the information, knowledge, and belief. So it's really important that you fill out this form correctly, that you do so with the guidance of a skilled, competent probate practitioner, lawyer who understands this area, and then file it with the court. And it's not a simple process because you have to file it. The court requires often some additional documents, including a notice of hearing, proof of service, and the order itself. So again, it's quite involved. And this particular form will then be used to close out the probate administration that has been occurring within that probate estate. At the Probate Pro, we're passionate about probate-related issues. If you have questions about the petition for complete estate settlement or any probate or trust-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.